Welcome everyone to the Federal Bar Association Ketam sections, the rounds, FCA news with Tejinder Singh. The rounds is Tejinder's regular analysis of noteworthy FCA decisions. I'm Scott Oswald. I am chair of the Ketam section with Tejinder Singh, who's a partner at Sparacino PLLC. Tejinder, today is our special end of the term Supreme Court update, and we have a lot to report about.
That's right. The big news is that the Supreme Court granted certiorari in the Polansky case. And then we also have a couple of pending petitions that the court has not yet taken action on, but that we'll expect to see action on at the end of the summer as the court kicks off its next term.
So let's talk about Polansky versus Executive Human Resources, Inc. The Supreme Court granted cert in this case, despite DOJ opposition. Is it fair to call this a surprise?
To me, it was a little bit surprising. So this case is one where there is a pretty clear circuit split. The case is about the standard that applies when the government tries to exercise its authority to dismiss a relator's case under Section 3730C2A. And different circuit courts of appeals have taken different approaches to this. And when there is a circuit conflict, you often see the Supreme Court wanting to wade in. In this case, the government said that the court shouldn't review it because ultimately the difference in standards doesn't often lead to different outcomes. In fact, the fact of the matter is relators never win these fights. If the government comes to dismiss your case, they're probably going to dismiss it because there isn't that much daylight between the different standards. But the Supreme Court decided to hear the case anyway. And I think that there are a couple of ways you could look at that. The first is you could say, well, the Supreme Court may honestly just want something where it gets to clean up a circuit split and it's not going to be front page news and there aren't going to be pitchforks on the Supreme Court plaza the next day. You know, they may be very eager to take some cases that are lower stakes than some of the cases that they have been taking. And the other way you can think about it is that even though the government says this is a pretty low stakes issue, it does fight every time this comes up in the courts of appeals. The government fights about what the legal standard is. And if the government really thought it was low stakes, maybe they would not fight so much. And so there may be some tension between the position the government took in opposing review and its actions in the various courts of appeals.
So let's talk about the potential outcomes here, including the position that Relators Council took as to how this problem should be resolved by the Supreme Court.
Yeah, so as I said, the courts of appeals have various different approaches. There's the standard from the Swift case in the DC Circuit, which says the government has unfettered discretion to dismiss Ketam cases if it wants to. There's the Sequoia Orange standard from the Ninth Circuit, which is kind of a version of rational basis review. There's what the Third Circuit adopted in this case, which is a version of how Rule 41 applies to the government's dismissal authority. And then the relator has a different argument. The relator says, actually, the way the FCA is worded, it says that the government, if it wants to intervene belatedly, it can only do so for good cause, and it can only do so without compromising the rights of the relator and the status of the relator. And that includes, according to the relator in this case, the right to conduct the action. And so the relator's position is that if the government doesn't move to dismiss the case in the beginning, instead it declines to intervene and lets the case go forward, the government loses its power to dismiss the case. Now, that's not a standard that any court of appeals has adopted, but this is an important point about Supreme Court practice for those who haven't done it. The court often takes cases to resolve circuit splits, but it is not limited to the approaches adopted by the courts of appeals. And so even though no court of appeals has adopted this rule, that doesn't mean it's off the table. You could see a textualist Supreme Court getting kind of interested in the relator's position, which is grounded in the statutory text, and saying, okay, that is a possible outcome here too.
So this has some real implications, though. The government over the last few years has been intervening in cases post declination, or maybe they issue a kind of a no decision, and then dismissing cases, but also then settling cases that have been litigated by the relators. What's the implication of the Supreme Court maybe taking up the relators' argument that, in fact, C3 is what controls?
So if the court accepts the relator's argument, I think it will limit the government's power both to dismiss and to settle cases after the fact of declination. What that means is hard to predict. It's possible that the government would just be more proactive at the outset in cases, understanding that it's one and done on those kinds of decisions. It's possible that the government wouldn't be more proactive and relators would just have more power over their cases subsequently. It might relieve the government of the burden of defense counsel coming to them again and again and saying, hey, do you want to dismiss this case? We've understood from some of our government colleagues that that's a common complaint of theirs, is getting lobbied kind of relentlessly as there are developments in cases. And so that might go away. The government may actually like that. It's also possible that somebody would change the statute. There's currently a set of amendments that are moving very, very slowly, but they do involve the government's dismissal authority. And it's possible those would be tweaked to accommodate what's going on or to modify it. So it's very, very difficult to predict. But what we do know is, as written, if the relator's position is taken, then the statute as written would limit the government's power later in cases, and the government would have to figure out how to respond to that.
So just remind everybody, the pending legislation, which touches on this issue as well as others, codifies, at least in part, what the Ninth Circuit has done, their test for C2A dismissals. What is that?
That's right. So there is a version of a bill reported out of the Senate Judiciary Committee that discusses dismissals. And the standard is, as I said earlier, essentially a form of rational basis review. The government's rationale cannot be arbitrary or fraudulent or contrary to law. That's the standard that's being proposed. And it's the relator, I think, who has the burden under the way the statute is written, at least I read it, to come up with that evidence. Now, of course, all of that could be changed on the Senate floor or through compromise with the House. So it's not final legislative language, but as it currently stands, it looks a lot like a codification of the Sequoia-Orange standard. And one thing that's worth pointing out in connection with Polansky is that even though the relator's frontline argument is that under the plain text of the FCA, the government just has no power to belatedly dismiss, he is going to make an alternative argument that he wins under the Sequoia-Orange standard. So I think they're padding that for a soft landing if the legislation is enacted or if the court rules that Sequoia-Orange is the right standard.
And so now the Supreme Court's taken that case up. What can we expect in terms of when oral argument might be and when a decision might come out?
The normal schedule for a Supreme Court case is that from the day certiorari is granted, the petitioner has 45 days to file a merits brief, and then it's 30 days for the response and 30 more days for the reply, as long as the reply can get in at least 2 weeks before the scheduled oral argument. Oral argument in the case has not been scheduled yet. I would anticipate it's going to be in December. Based on how the court's schedule normally works. They've already filled the October sitting. And so if you look at the normal briefing schedule, the reply brief would be getting filed around October 6th right now. I think there's going to be room in the schedule for the parties to seek extensions. And so it's possible they'll move that out a little bit as long as the replies are in 2 weeks before argument. So I would expect the briefing to be completed sometime in November and for the case probably to be argued in December. But we don't know. The court doesn't make its entire argument schedule public all at once. And so we don't yet know what's being argued in November, December, and January and how the cases are being split up.
So let's turn to other action before the Supreme Court. We have a number of different petitions that are pending there as the Supreme Court term ended. What's the status of other FCA related actions before the Supreme Court, Tejinder?
There are two major issues pending before the Supreme Court. The first is about the application of Rule 9b. There are 3 cert petitions, 2 brought by relators, 1 brought by a defendant, all asking the court to take this up. The court called for the views of the Solicitor General in one of those cases, and the SG's office said, deny review, this isn't really that big of a split. And then a response was filed. And just full disclosure, I'm involved in all 3 of those cases representing the relators. And what the court did was it didn't take action on the petitions at the end of the term. Instead, it looks like it's going to wait until the fall, because what a second thing the court did was it called for the government's views in another one of those cases. And so the government hasn't yet filed that brief. So my thought is that what's going on is the court is going to wait to get that government brief, and then they're going to consider all 3 petitions together at the conference at the end of September. And then if certiorari is granted there, we would expect those cases to be argued probably in January or shortly thereafter. And then the second issue that's currently pending before the Supreme Court is the scienter question presented by the Schutte versus SuperValue case. And there's a cert petition filed, and that's going to go through its ordinary briefing process. The cert reply is actually being filed right now, and the case is going to be distributed for conference. But the conference it gets distributed for, because the Supreme Court doesn't consider petitions over the summer, is going to be at the end of September. And so we'll find out at the same time whether the court is going to hear that case. It's also possible that the court will call for the views of the Solicitor General in that case, which may extend out the schedule on the cert petition even further.
Sounds like a lot to watch for. Tejinder, thank you. And thank all of you for joining us for this edition of The Rounds with Tejinder Singh. We will look forward to seeing you later in the summer for our next edition. See you then.